probate and so forth. You only specialize in Florida, is that right? Or just Brevard County or other
Well,
counties?
in Florida, but, as far as Medicaid planning, it's such a dense area of the law. Typically, attorneys don't go outside of their county. As far as other things that we do, like probates and, estate planning, that can be anywhere in Florida. But from a pragmatic standpoint, I serve Brevard County. Every now and again, I get some clients outside of Brevard County, but it's not too often.
Well, when I interrupted you, I think we were going to get ready to talk about estate planning, I believe is where we were going with that.
Okay.
Tell us a little bit about what you would advise people on estate planning. Exactly what does that mean?
Okay. Estate planning basically, in my estimation, entails moving your assets to your loved ones in the most time and cost-effective manner possible. Okay, that's fundamental estate planning. I mean, estate planning can get a lot more complicated than that if we're dealing with the very wealthy. Right now, each and every person has a $5.5 million estate tax exemption. And if you're married, you can double that up. So we're not doing a whole lot of estate tax planning for people in Brevard County anymore. That knocks most of us out. I know it certainly knocks me out. I mean, I'm only 43, but I'm not a multimillionaire yet.
I know that's a pretty big figure,
right, and it's adjusted every year for inflation, and especially if you're married, you double that up, so you're looking at 11 million.
Mm-hmm. So let's kind of get a typical scenario. You've got someone maybe coming in at 50 years old, and they want to talk about not only their own estate planning, but maybe they also want to talk about their elder parents, and they want to get advice for both generations. What do you like to start with? You want to look at their portfolios, their income, have a budget? Where do you start with?
Honestly, we start with just general figures first. I like to look at what the assets are and how much they're worth, because initially I just have to know if I'm dealing with a taxable estate. And back in the day when I first started, when the estate tax threshold was much lower, around $1 million.
Yeah, I can remember that. Wasn't that many years ago? It doesn't seem.
Right. We had to do a lot more trust work in regards to estate tax planning. Now, I just to be prudent and so I don't commit malpractice, I still kind of have to get the values of what you have.
We don't want you to do that.
Right. And sometimes people are a little, wary of exclaiming, how much they have. They may think that you're going to charge pursuant to that. And I try to say, look, I'm not trying to be nosy, but this is for whether, this is knowledge I need to have in regards to whether I need to do tax planning for you, or at least tell you that you may have to do it, whether you do it with me or somebody else. And that typically loosens them up. But since tax planning typically isn't what we're doing a whole lot of these days, we're looking at probate avoidance. Okay. And probate's not a tax. Some people think that it is. But that's basically the circuit court process whereby your assets are moved through the circuit court and the circuit court judge makes sure that the retitling of your assets actually happen according to the language of your last will and testament. Okay. And because it's a circuit court process, there's lots of statutes and lots of rules that need to be abided by, and that creates a lot of work for the attorney. So for probating, a relatively larger estate, it's good money for the attorney. We get 3% of the gross, which can be a pretty high number. A lot of people want to avoid that, and I don't blame them. It also can be time consuming too. Probate can be from anywhere from 6 months to a year. Yeah. It can drag on for longer than that. So a lot of my clients, they're interested in avoiding that. And I don't blame them. I mean, if probates land on my lap and I didn't do the planning, it's good money for me. I love it, whatever. It's part of what I do. I know how to do it. My clients come to see me early. I tell them all the mechanisms, and there's some very simple mechanisms they can use to avoid probate. We typically use a combination of a simple will, pay on death and transfer on death beneficiary designations, and sometimes we use what's called a revocable living trust.
Let's talk about that second one. You said a simple will, and what was the other one?
They're called pay on death or transfer on death beneficiary designations. In Florida, we've made it real easy, and I'm sure other states have too, but you can go to let's say you have a $50,000 mutual fund at, I don't want to name a bank, a local bank.
Right.
And
the First National Bank.
Right. And you want that mutual fund to avoid probate upon your death. And again, let's take the example where you're a single person.
Right.
You can go in there and sign a beneficiary form naming your 3 kids to get that asset in equal shares. It's called moving an asset by operation of contract. And when you die, your kids just show up at the bank with your death certificate and they cut 3 checks.
Bing, bang, boom.
Bang, 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 boom. If that would have had to have flowed through your will otherwise, and it would have had to go through the whole circuit court procedure of probate.
I'm not sure my mother had that, but I know she had some kind of a trust that she had set up,
right,
where everything, the very next, I think it was within 24 hours, just everything reverted to me and didn't have to go through probate or anything, cars, everything. You think that was
It was probably what we call revocable living trusts. Some people know them as living trusts. Some people just simply know them as trusts. For all intents and purposes, they all mean the same thing. Mm-hmm. I mean, there's all sorts of different kinds of trusts that we don't have to get into this evening. But as far as the main trust that elderly people talk about and think that they want, it's the revocable living trust. And it's simply called that because you can revoke it at any time. You can amend it at any time.
Do you want to stay on the friendly side of your parents?
Of course, yes.
All the time for not only those reasons.
You don't want them thinking they're moving their assets into something that they've lost control over. I heard your last segment. Yeah, the elderly people don't like losing their independence, and that's just how it is. And I know I'm going to be the same way with my personality. So
when you start getting rid of cars and houses and their independence, they don't like that. They want, as you said, they want to feel like they're still in control of their life. So being able to do this up front, at least they know that they've been in control of that particular situation. So we have the simple will, we have the revocable trust, and we have the
beneficiary
designation.
And oftentimes using a combination of 2 of those things, sometimes all 3, you can completely eliminate probate. I mean, if you have a revocable living trust in place, that can cause absolute probate avoidance. It's basically this intangible entity, this contract, if you will, that you sign, and you move your assets into it while you're alive, and you still completely own those assets while you're living, except after you've died, you've kind of contracted with someone that we call a successor trustee. They're basically the executor of the trust. Mm-hmm. And when you die, they have instant fiduciary access to all the assets that you've moved into this thing outside of the circuit court's reach. So they can immediately start contacting all your banks and whatnot, liquidating all these things. They can get your taxes paid and then distribute the remainder to the loved ones. The beneficiaries is the technical term. Mm-hmm. And all those assets, again, have avoided the probate process.
Well, on the revocable trust, I have a question here that you brought up. You still have to have a simple will with a revocable trust? You
don't absolutely have to, but every prudent attorney usually drafts what's called a pour-over will. And that's simply a catch-all. Let's say I've done some planning for a 67-year-old gentleman. And we've signed this trust, and we've gotten all of his assets into it, his house, his checking account, savings account, money markets, all of his money assets are in there. And then 5 years later, he walks into a bank and invests $50,000 in a new certificate of deposit, let's say. And he just forgets to put it in his trust. So we thought we got everything in that trust, but now there's this CD that has $50,000 in it that's going to be in his name alone when he dies. So he dies, his will would catch that $50,000 CD or certificate of deposit and then pour it into the trust. And then it would be distributed pursuant to the language that's in the trust. Now, you still don't want that to happen because there's going to be a probate from the will to the trust. So you want to get these trusts properly funded. And there's other estate planning attorneys out there that say, oh, that's why I don't like trusts, because they never get funded properly, and we have a probate going on at the same time as a trust administration. And I've heard that argument, but I can tell you this. A small probate, when most of your assets are in a trust that avoid probate, in my estimation, my experience, is a lot less invasive than all of your assets going through probate. But again, that's this just this attorney's opinion.
What a good attorney, because you are the master of law.
The master of laws in estate planning and elder law.
And tell me how you get that title of masters of law, because that takes extra education.
It's an extra year of law school, and they've been around forever. And typically they were devised for people that practice in taxation or corporations, very dense areas of law. Now estate planning and elder law is getting to be more at the forefront of what society is going through. There's lots of schools now that are actually developing elder law and estate planning LLM programs. And it's an LLM degree. It doesn't have an exact interpretation. It's Latin, but we call it a master of laws.
I like it. It sounds good.
Right.
I always tell people I'm the queen of the world, so right. Masters of law sounds just as good.
Yeah, it's kind of like backwards. When you're a lawyer, that's kind of like your doctorate, but not really. But you get your doctorate first and then your master's later. Mm-hmm. Whereas everybody else gets their master's first and then they get their doctorate after that if they decide they want to go through more torture.
So you do a lot of speaking in the area and helping the community understand a lot of these different ideas and so forth. If someone wanted to just get a general idea of what's going on, do you have a package? Do you have some kind of a price range that if they come in and they speak to you for an hour and that you can do a simple will and so forth and it's X amount of dollars? Do you have something that available? Because a lot of people are thinking, it's going to cost me $10,000 to get his advice.
First of all, most of my consultations, the initial consultation is free, especially if it's involving estate planning, guardianship, probate. Because basically people, they come in, they have an issue, they give me a set of facts, I loosely apply those facts to the law, and I tell them whether I can help them or not. And then I quote basically usually a flat fee according to how in-depth I think the case is going to be. And then we kind of contract from there. And they don't have to obviously decide on the spot. I give them a contract. They can take it home, throw it away, or they can take it home, think about it, and bring it back. With long-term care, oftentimes I will charge for those because I'm asked very pointed, direct questions that are subjecting me to liability. So I'm engaging in a very serious area of practice just by giving this consultation. So sometimes I do charge for those. And I'll tell people in the beginning of the consultation or on the phone, they're told ahead of time that a long-term care consultation could be free. If it starts getting into more dense areas, the attorney will let you know the free has probably just converted to a pay. You don't have to move on if you don't want to.
Mm-hmm. Well, I think that's great because people, again, sometimes people are afraid to reach out and get this information because they put it off because they think it's going to be too expensive or someone's going to talk me into something I'm not too sure I want. That's why we search out for the experts that have that teacher's heart. I like Dave Ramsey. He's always talking about find the expert with a teacher's heart that wants to educate the public on what's available and not the salesman's heart. So we are here to help you make those decisions at your Hometown Solutions. We only have about a little over a minute left. Okay. Alec, tell us a little bit more about what you could share with the community as far as advice right now that they might need to know as far as where they are in their estate planning and so forth. If they have nothing, is that the good time to come see you?
Yeah, I mean, initially, when you start moving through your 50s and into your 60s, you at least should have your wills in place, your durable powers of attorney in place, your healthcare surrogates in place, and perhaps your living wills. That's your fundamental estate package. So your wills, okay, if you haven't done any further planning, you may not be escaping probate, but at least you have some instrument that explains to the world where you want your stuff going.
Exactly.
That's not such a bad thing. Your power of attorney will allow your named fiduciaries therein to handle your finances if you lack capacity, thereby enabling you to escape guardianship. A healthcare surrogate allows the people named therein to talk to doctors for you if you ever lack capacity. And of course, I think we all know what a living will. We sometimes call it the Terry Schiavo document. It's like, look, if basically I'm hooked up to machines and you've done all you can, it's okay to take me off.
Wow, lots of good information. AlecPrentice, thank you for joining us today on Your Hometown Solutions. Give out your website one more time.
It's PrenticeLaw.com.
Prentice